Hello, today my guest is Bill Sulzer, who is the managing member of the law firm Griffin, Coogan, Sulzer, and Horgan PC. For over 25 years, Bill has focused on representing property owners in tax certiorari and valuation related issues throughout New York State. His practice has encompassed virtually every property type, and he successfully argued appeals and litigated complex issues relating to constitutional issues like equal protection and due process claims, the legality and enforcement of settlements, property valuation, and real property tax exemption. Bill's firm represents owners in Westchester, Rockland, Dutchess, Orange, and Putnam counties. And when my firm's clients need assistance in property tax issue, Bill and his firm are our go-to guys, and we frequently collaborate together. Welcome, Bill.
Thank you, Stephen. It's nice to be here with you today.
Sure, and I'm glad to have you here. So before we get into our discussion about the nuts and bolts of tax certiorari proceedings, which I know our audience will definitely be interested in, and your predictions for 23-24 valuation trends, can you just tell us about some of the real estate issues that your firm handles? I guess tax certiorari and any other sort of related issues that you handle.
Sure, we are really a tax certiorari boutique firm. We focus our practice in all types of real estate valuation related issues and exemption issues. I do have one colleague who works with me who does just general real estate and some trust and estates work, and he has an associate who works with him. But myself and two other attorneys devote 100% of our time to tax certiorari issues. So we're really a boutique type firm. There's a lot more that we don't do than we do. We try to limit our practice to what we know and what we're good at.
Right. And who are like some of your like typical clients? Like what's your client base? I guess anyone owns property, but like give us some examples.
Sure, we represent everyone from the local person who owns a single family house. We represent utility companies. We represent co-ops and condos and shopping centers and corporate owners. We've represented some Fortune 500 companies on seeking reductions of their real estate taxes. We represent developers. And if you own real estate, we're available to help you when needed.
So how is real estate taxed in New York State?
Sure. Real estate is taxed in New York State on an ad valorem basis. So each year the assessor has to put an assessment on your property. In New York State, there is no mandate that assessments be updated on an annual basis. It's only one of several states in the country that has that fact pattern. So as a result, the decision to value property or revalue property rests on all the local jurisdictions. So in Westchester County and a lot of the surrounding counties, there's communities that have not updated their assessment roll in 50, 60, 70, some back as far as 100 years. So what we generally find is that every year the assessor in those communities just takes the prior year's assessment and rolls it over to the new year. And there are certain communities in Westchester County and in Putnam County and some of the counties up north that do what's called annual revaluation, where every year the assessor goes out and he or she places a value on the property. And the goal in those communities is to keep the assessments at 100%. So within these counties, there's really two different types of systems. There's the towns that revalue, where the assessments are changing every year and their assessments are 100% of value. And then there's the jurisdictions that don't revalue property, where you're looking at assessments that may be 50, 60, 100 plus years old.
Right. And which system do you think is more common?
I think it's more common around here not to do revaluation. Right now in Westchester County, for example, the towns of Pelham, Rye Town, the town of Ossining, the town of Greenberg, the town of Mamaroneck, and the town of North Salem do annual revaluation, where every year the assessor is looking at all assessments within the community and making annual adjustments if necessary, and all the rest, and the Village of Bronxville also, and all of the rest of the assessing jurisdictions in Westchester County do not do revaluation. So the responsibility to monitor your assessment really falls on the taxpayer, and they really should know or look at their assessment every year to see what the assessment equates to on a market value basis. Because assessments are not updated in the non-revaluation communities, what will happen is the assessor puts out an assessment roll, and that assessment roll is based on a percentage of value called the equalization rate. So every year, the state and all the communities that don't do revaluation establishes the equalization rate. And the equalization rate is a function of the sales within the last 12-month period and certain appraisals they do. And that you divide your assessment by the equalization rate to get your full implied value. So when the assessment roll is published, anyone can look at the roll and see what their assessment is and what their implied value is to determine whether or not he or she feels that, bears any relation to what the actual value is. Because of this system, in year one, when you look at it, your assessment maybe equate to an implied value that you think is fine. But if there's significant changes in that ratio over a period of 2 or 3 years, as the ratio changes, the implied value changes. So because the biggest variable that the state looks at is residential sales within the community, and the residential sales, like during the COVID, residential sales were booming, where residential sales are up a lot, that drives the ratio down. So when you're dividing these commercial properties by a lower ratio, you're getting a higher value. So what we find is that because of the system is kind of flawed, it's very easy for properties to get over assessed fairly quickly through no fault of the assessor. It's a function of the methodology the state uses and the towns are required to use because they don't revalue property.
Right. It seems like it might not be intuitive for a property owner to reach that conclusion if they don't have that sort of knowledge base that you have.
No, definitely not. People get a tax bill and it may say their assessment is $10,000 and they think that's their taxes. What you have to do is divide your assessment by the ratio to get what the full value is to determine whether or not you should file an appeal. To make matters a little more complicated, there's 2 separate ratios that are put out every year by the state. There's one called the equalization rate, and there's another one called the residential assessment ratio. The residential assessment ratio is a ratio that we use when we file a tax appeal on behalf of a 1, 2, or 3 family owner-occupied house or a lot that's not of sufficient size to contain a residential structure. So when people call us up, first thing we ask them is what type of property is it, and then we know what ratio to look at when we're figuring out what their current town or city value equates to.
Right. So I know like New York City has its own sort of calendar, and a lot of the towns do. So for doing this, like the whole procedure, but like what's sort of like in broad strokes, can you explain sort of the course of a year or years, like the whole tax certiorari process? And I know it differs town from town, but sort of like in city to city.
To file a tax appeal, it's a 2-step process. The first step is you look at the assessment roll, figure out what your value is, and you file what's called a tax grievance or tax protest. That grievance gets filed with each municipality's Board of Assessment Review. The board, once the assessor publishes the assessment roll in tentative form, the ability to make a change rests with the Board of Review once the assessor puts out the tentative roll. So you have from the day the roll is published to grievance day to file a grievance with the Board of Review. The board then deliberates and meets and reviews all the grievances that are filed. Generally speaking, we find that in most cases, the board will deny the grievance. And the next step is you file a petition with the court. The petition must get filed within 30 days of the publication of the final roll. If you have a 1, 2, or 3 family owner-occupied house, you file a SCAR petition, which costs $30 to file. Those cases get heard by a hearing officer. Generally speaking, they're all resolved within 6 to 12 months of the initial filing. The commercial cases, it's a much more complicated process. You file a petition on what's called an Article 7 petition, also within 30 days. You serve the town or city, serve the county, serve the school district, but then your case gets lumped in with all the pending certiorari cases. So at any one time, there may be several thousand cases pending, for example, in a given county. So you get lumped in those cases with all the pending cases. They all get heard by one Supreme Court judge who sits in each county. There's one judge, generally speaking, there's one judge assigned to hear all the certiorari cases for each county to keep the calendar simpler for the practitioners and to keep the case law clear for the practitioners so they know what to expect. But generally speaking, a commercial case, typical commercial case takes several years to get resolved. So what happens is you may file, say you have a building in White Plains and you want to you file your grievance in January, you file your petition in March. That petition then gets placed in a pool with all the other petitions. If the case is not resolved by the next January, you have to go through the process again and file a new grievance and a new petition and continue that pattern until the case is resolved. Once the case is resolved, if it's successfully resolved, the city, county, and school district will issue refunds based on whatever the corrected assessment should have been. And going forward, your assessment gets changed. What will happen is if you have an appeal that's successful, the law requires that once the judgment is signed by the judge, The corrected assessment must stay in place for a period of 3 years during which the taxpayer can't challenge it and the town or city can't change it. Unless, of course, you do physical improvements, there's a catastrophe, or the town or city opts to do a revaluation. If a town or city is doing a revaluation every year and they're looking at all property within the community, the assessor has the ability to make annual adjustments. So notwithstanding the fact you achieve relief the next year, the assessment may go up the next year. We generally try to convince the assessors to use the corrected number as the basis for any trending they be doing for market conditions. But it is, although it's a more accurate way of valuing property to look at it every year, which the assessors do in the revaluation community, it is somewhat harder for those property owners to manage their tax burden because their number is constantly changing. So they need to be pretty vigilant about checking the assessments to make sure that the assessment wasn't changed to the point where it's no longer reasonable and within the range what we consider to be equitable.
Right. So then just so like, I get that that's the, there's a pretty detailed process there, but what would it say like a property owner, do to get started, just like in simple terms, how
Sure.
how do they get the ball rolling?
Sure. I mean, if a property owner calls us, the first thing we ask is, we'll start with residential property. We say, describe your house, give us the number of bedrooms, give us the number of bathrooms. Have you recently had it appraised? Give us the style of the house. When did you buy it? The case law holds that a recent sale is the best evidence of value. So if there's a recent sale that's below what the implied value is, we know that there's merit for relief. And if the sale price is above what the assessment equates to, we know there's nothing there. But then generally what we do is we have access to MLS. We'll look for comparable sales within the area. And we look at those comparable sales to see what similar houses in the market are selling for. And that's how we analyze this, the typical residential case. So we'll look at, maybe 5 or 6 sales, see where they're at. And generally speaking, we can pretty much eyeball and get a good feel about whether or not a property is overassessed based on the local market activity. Commercial properties are somewhat different in that if there's a recent sale, that's still the best evidence of value, but the preferred way to value those properties is to look at the income and expenses for the property, figure out what the net operating income is. So what we do is we'll ask the property owner for 2 or 3 years of profit and loss statements, a current rent roll, to see what the different spaces are renting for. We'll ask if they've had the property recently refinanced, if there was a appraisal report done, if they've done any gifting and had a report done. And then what we do is we do an analysis of the income and expenses. Sometimes we consult with a licensed appraiser in New York State to get their view of what they think the property is worth. And we'll compare what we conclude the value to be. What we do is we figure out what all the income is, figure out what the vacancy rate is. We come up with an effective gross income. We then deduct what the expenses are that are associated with managing the property or running the property. We come up with a net operating income, which we then capitalize into a full market value. We then compare that market value to the town or city value to figure out, hey, is this property overassessed or not? Co-ops and condos, in most communities in Westchester, what the properties sell for, what either the shares sell for, what the units sell for, is totally irrelevant for purposes of determining the assessment. So the case law is that, and the statutory requires that you have a property in a revaluation community that's a co-op or condo, the assessor must value it as though it's an apartment building. So what the individual units sell for is not helpful to us. What you have to do is attribute a rental rate to each unit as though it's being run by one investor as an apartment complex. Figure out what the rents are, figure out what the expenses would be if it was hypothetically run by an investor or owner, and then come up with the net operating income, and then come up with a market value, and then compare it to what the total aggregate value of all the condo assessments is, or compare it to what the value is for the cooperative assessments, and figure out whether or not it's overassessed. So the way they value it is really a fiction. It gets valued as though it's a fictional apartment complex, which in most cases is very beneficial, because generally speaking, the income approach to value leads to a much lower value than if you would add up the total of all the sales within the complex. So in some cases, we're seeing, assessments that are, should be 30 to 40%, maybe sometimes even as high as 50% of what the sale value would be for condos and co-ops. The exceptions to that are the town of Pelham and the town of Rye have a different system in place where if you're an as-built condominium, you get valued based on what your sales are. Co-ops still get valued based on income, but if you're an as-built condominium, they use what's called the homestead tax option, and they value those units based on the sale price. So for those type of units, it'd be the same analysis we do for the single family house. We look at what the sales are within the complex or in the outside area for similar condominium units, figure out how they relate to the assessments.
Right. So when you say an as-built condominium, you're talking about something that was built by design, not a conversion. Is that
Correct? Yeah.
Right.
Yeah. If you're a converted condo or co-op, you still get the benefit of the income approach to value. Whereas if you're as-built condominium and the Homestead Act is adopted.
Right. Now I know you'd said that the commercial process takes longer. What's the timing on, I guess, residential, petitions, or like a case start to finish for a particular tax year? And the same thing with co-ops and condos, since they seem to track the commercial. Does that take longer? Or
Yeah, that definitely takes longer. So the simple residential case, you file the grievance, you file a petition, the court will call up either you if you file it on your own, or call up us as the attorney who filed it, and they'll schedule a hearing date. We always try to reach out to the assessor before the hearing date and figure out if we could work something out. We'll give them recent sales or whatever data we think supports a reduction. If there's a contract to sale, that's the best evidence of value. Otherwise, what we need to do for the typical residential case, if we can't get it resolved amicably, is we have an appraisal report done, typical appraisal report, depending on the size of the house, $500 or $600 for a typical house, maybe a little more for a higher end house that's bigger and requires more work by the appraiser. But we have that report done. We're able to settle, I'd say 98 to 99% of our cases without the need for a trial. If we can't work it out, both sides are required to exchange their reports or their evidence the day before the hearing, within 24 hours of the hearing. And then we present the evidence to a hearing officer, who then renders a decision. If the homeowner is dissatisfied with their decision, they can file an Article 78. The town or the city doesn't have that same luxury. They're stuck with whatever the hearing officer decides. There's no appeal process for the town or city. And then what will happen is, depending on the timing, if it gets resolved before the tax bills go out, in some cases, the assessor will go in and make the change to reflect the corrected number before the bills are issued, so that the taxpayer starts to realize the benefit of the corrected assessment right away. In other cases, if the hearing was after the initial bills go out, we then serve the stipulation or the court's decision on the taxing authorities, and they're required to refund to us the overpayment of taxes that were made on the portion of the assessment that was determined to be excessive.
Right. Now, what about, when you're evaluating these cases, is there really, let's say, a potential client calls you, is there any downside for them? Like, how do you determine whether to file a case? Is there ever a situation where you file a case and it works, it works against an owner, let's say?
Sure. It's a very good question. In the communities that do not do revaluation, the assessor is precluded from increasing the assessment unless there's a building permit taking out. They can't reassessment based on sale or based on any evidence that they find. So generally speaking, we find that in the non-revaluation communities, there's very little downside to the typical commercial property owner to file, because if we determine there's nothing there after we file, or if it's close, we give the taxpayer the option. Do you want to get an appraisal report and go forward or not? But if we determine the property is equitably assessed, for example, we just drop the appeal. There's no risk of an increase in assessment. In the revaluation communities, we have to be very careful about what we give the other side, because they're looking at assessments each year. The assessor has the ability to make a change the next year. So we don't like to file in the revaluation communities unless we are 100% confident that we can help and that the property is overassessed. Because if a property is assessed for 10 million and we have it appraised and it shows 11 million, and the town hires an appraisal and they show it's worth 11 million, next year there's a chance the assessor could use that appraisal report as a basis for changing the assessment because they had it for too low. So in the revaluation communities, there is a risk. In the non-revaluation communities, there's no risk to filing. The other thing I'll point out is sometimes people will do improvements in their house without permits. We have to be careful about those, because we don't want to draw attention to, if someone redid all the bathrooms, redid the kitchen, finished their basement, and they're close to being equitably assessed, we'll say, listen, it's just not worth it, to highlight all this to the municipality's attention. It doesn't make sense. So we're better off to leave it alone. Other times people will call us up and they'll say, I bought a house. The municipality doesn't indicate that it has a finished basement, but I bought it for $800,000 and it's worth and the assessment is $1 million. In that particular case, we may say, well, it may be better for you to legalize your basement because we can reduce your tax assessment by 20% because you paid $800,000 for a house with a finished basement and it's assessed for $1 million. So that tells us the house is only worth $800,000 because that's what you paid. So we have to be somewhat selective about what we do when we open a file.
Right. So you might have already covered this, but let's just say like from a commercial, and you probably did cover this, but let's say from a commercial property owner or let's say a residential property owner, is there like a risk that if let's say they do a renovation and they file permits that the assessor is going to sort of preemptively or just sort of on their own take the initiative to reassess, or is that
Yeah, that's another good question. The assessor always gets a copy of any permits that are filed with the building department. And because the assessors in most communities are constrained from increasing assessments, they're pretty vigilant when it comes to permits. So if someone takes out a permit for $50,000 worth of work, we often find that the next year the assessor will make some type of increase up to $50,000 to reflect the value that was added to the property. Replacing a roof, something like that doesn't add value because, a house needs a roof, house needs windows that function. But if you're doing work to enhance the value of the house, and the rule of thumb we tell people is if the work you're doing is going to enhance the sale price of the property, you should expect the assessor to increase the assessment up to the value that you're adding. The costs generally represent the upper limit of value. So if you do $50,000 worth of work, the assessor should not be increasing you $150,000. If he or she does that, there's case law which says that's unlawful and that that's impermissible, and we can get it rolled back to what the value that was added was worth. But we tell people, be careful when you're filling out your permits. Don't be ultra aggressive. If you're going to err on the side of caution when filling them out, so as to not warrant an increase beyond what you're doing.
Right. And then does that also apply to commercial properties? Would it be similar or not really?
Yeah, commercial properties are a little more, we're not as concerned with commercial permits, generally speaking, because a lot of the work that's done is just done to satisfy whatever needs the new tenant has. So if you were getting $25 a foot for the space and it was a spa and, now a restaurant's moving in or an office is moving into that space and they need to spend $50,000 to renovate the space to accommodate what they're going to be doing, but they're still paying $25. Those type of increases generally don't lead to changes in the assessed value because you were getting $25 before, you're getting $25 now. The fact that someone had to do $50,000 worth of work is unfortunate, but it's, that doesn't really enhance the overall property value.
Right. So can you tell us like any recent success stories or interesting, I guess, stories where your firm handled the case, and helped the property owner out?
Sure. We had a tenant who contacted us who was very unhappy with their tax assessment in one of the local communities years ago. They were a tenant paying 100% of the overall taxes. So we filed a grievance on their behalf for several years. The town acknowledged that the property was overassessed, but because of some case law that they found coming out of the city, they took the position that only an owner could file the tax grievance. For as far back in New York as we could find through case law, a tenant always had the right to file a tax appeal if they were paying the landlord's undivided interest in the taxes. So if you have a tenant like a Walgreens or a CVS that's paying 100% of the taxes, the law was that that tenant could file a grievance and could file a petition seeking review of their assessment since they had standing to file. The court in that particular case dismissed the petitions because they said the owner had to file the grievance contrary to 100 years of existing law. And the appellate division, surprisingly, sided with the town and ruled that the petitions were dismissed because only an owner could file a grievance. So after 4 or 5 years of litigation, we took the case up. We filed the case with the Court of Appeals, and the Court of Appeals granted our re-argument, motion for re-argument, and then heard the case. And the Court of Appeals ruled unanimously in our favor. So that case was DCH versus the town of Mamaroneck. That case had broad implications throughout the state because communities everywhere were taking the position that if you had a land lease, if you were not the owner Anyone who filed a grievance on behalf of the tenant, those petitions were subject to dismissal, and motions to dismiss were being filed all over the state. So at the end of the day, we had a client that got a significant refund in taxes and got a correction in their assessment.
How are fees typically calculated? In other words, the attorney's fees calculated on
Sure.
matters.
The typical case for residential will start for the 1, 2, or 3 family houses. Our typical fee is 50% of whatever we save you for the first year. So our fee is contingent on achieving actual savings. If we don't achieve relief, we don't get paid. So we try to be pretty selective about which cases we take to make sure that we're going to be able to help the owners. For the typical commercial case, the standard fee is 1/3. If someone's got a portfolio of properties and has a lot of buildings, we'll consider, a reduced fee if they give us volume of work. But what we do is we look at the information, we ask them for the profit and loss statements. Most commercial cases will check with an appraiser for their opinion, so we're certain that we're going to be able to help them. And the appraiser can crunch the numbers on an informal basis and give us what they think the value is, and then we'll make the decision. We then send a proposed. There's 2 items which are necessary for us to move forward. We need a signed authorization form, which gets attached to the grievance and then subsequently the petition. The law in New York State is that every year you need a current authorization form dated in the year of the filing. So if we file for you in year 2022, case isn't resolved yet for a commercial property, we need to file again in 23. We need to go through the process again and get a new signed authorization form for 2023.
So what are some, let's say, if you had to say that there was a common misconception, or just if you just want to throw out some tidbit about what you think property owners, generally don't know that they should know, or just a misconception.
Sure. I think, I think property owners should be vigilant and be checking their assessments either annually or every other year to make sure that that implied value bears, relation to what the property is worth. You may have a property, you may have bought a commercial building for, say, $1 million 5 years ago. And when you check the assessment 5 years ago, it equated to an implied value of $1 million. Now the assessment may not have changed, but the implied value may equate to $2 million because of the change in the ratio. So a lot of people who call us, when we tell them and we're able to achieve, meaningful relief, 40-50% reduction, they say, well, can't you go back for the years prior to the filing? And we can't. We can only achieve relief for the years where we file a grievance and petition. So if we determine that your property is overassessed by 50% for 2022 and 2023, we can get those years corrected, get your refunds and reduce tax bills going forward. But if you're overpaying by similar percentages for the earlier 3 or 4 years, you've waived your right to relief for those years. So it's important for property owners to check with attorney or check with a local real estate professional, get a feel for what their property is worth to make sure they're not overpaying. There's also a misconception among some people are just very afraid to have any kind of interaction with the municipality. They don't want to make waves. They'd rather leave well enough alone. In some cases, we find people who overpay in their taxes by tens of thousands of dollars a year. We have property owners, we've achieved hundreds of thousands of dollars of annual tax savings when we file an appeal for them, and they just never focused on it before. They focused on it 15 years ago and never looked at it again. So it really does behoove owners to be vigilant and to call someone or to speak with a local professional, whether it be a real estate agent or a real estate appraiser, and just check their assessment from time to time. If you have a significant event at your property, such as a flood or a fire, it's important too that you bring that to the municipality's attention, because the assessor only has one opportunity a year to change the assessment. It's the day the tentative roll is published. So if you have a property that the tentative roll is published, say, on June 1st, and you have a fire on, say, February 28th, you need to bring that to the assessor's attention, because if he or she doesn't change your assessment on June 1st, they can't change it again until the next June 1st. And by then, if you've restored the property to its original condition or a similar condition, you're going to be overpaying your taxes during that subsequent tax period. So it's important to if you have a catastrophe, bring it to the assessor's attention or the municipality's attention, because sometimes they just simply miss it. There's no bad will. They just are unaware. They were never alerted that there was an issue.
Right. So I know you don't have a crystal ball, which is something I say to a lot of people that I speak with. But what are your predictions for the real estate market or trends for the 23-24 tax years?
Sure, I think that the two types of properties that are most likely to have success going forward are office properties on the commercial side, because with everyone working from home for COVID, there's a lot less demand for office space. The other thing that I think is important for 23 and 24 is when we determine what a property's net operating income is, we then divide it by what's called the capitalization rate, which is the rate of return. Because interest rates were historically low for such a long period, capitalization rates were very low. So it was very harder for us, because the lower the cap rate, the higher the value. Since the Federal Reserve started increasing the federal funds rate a year ago, capitalization rates have started to rise significantly. So everything could be the same at a property. The rents could be the same, the income, the expenses can be the same, the net operating income can be the same. But because of changes in the capitalization rate, a property that was worth 10 million 2 years ago may be worth 8 million now, because you're using a lot higher cap rate when you value the property. So if you have a condo or co-op, you should, it's important for those managing agents to be checking the assessments, or for the boards to be checking the assessments. You have an office building, it's also important. We're finding that warehouse properties are doing pretty well. They've withstood COVID a lot better than other types, because there's a demand for warehouse space because of all the online shopping. Retail is hit or miss. Some retail centers are doing well. Other retail centers generally are struggling. It really depends on what kind of tenant mix you had in the property prior to COVID. Even the shopping centers that had Class A tenants, that are nationally known, during COVID, a lot of those tenants asked for rent reduction. So we did see a decrease in the value for those properties, just not to the same extent that we're finding for office properties. And in terms of the residential market, the 1, 2, or 3 family homes, there's a lot less refinance activity going on now because the interest rates are so much higher. So the refinancing market seems to be pretty slow. Also, though, the inventory is pretty slow, because people who have a mortgage at 3% are not very inclined to sell. They're going to have to be paying 6 or 7% on a bigger house with a much higher mortgage. So the fact that they have that low interest rate on their mortgage is really an asset that a lot of people are unwilling to let go of now. So we're seeing somewhat less activity in the residential market. There are still sales, but it's slowing down a bit. But we haven't seen, in Westchester at least, we haven't seen a significant decline in the values thus far.
Right. So, you're a real wealth of knowledge, Bill. I learned a lot today. I'm pretty familiar with the process, but there are definitely some details of that I wasn't aware of. And I'm sure our listeners got a lot out of this. So how can they contact you? How can people reach you, Bill?
Sure, they can call me at my office in Bronxville. My number is 914-961-1300. We also have a website, Griffin, Coogan, Sulzer, and Horgan, if they want to Google it. Or you can reach me by email at W for William, E for Edward, S for Sam, @gcshLaw.com.
All right, listen, it was great chatting with you, Bill. Thanks so much for your time, and I look forward to speaking with you again sometime soon.
Great, thank you for the opportunity.
All right, bye.
Bye.
Thank you for tuning in. If you enjoyed this content, please click like and subscribe. And remember to make every day great.